All right, good morning, everybody. My name is Kaylee McNellis, and I'm one of the article editors and board members of the Law Review. I just wanted to take a quick moment to thank you again for coming to today's symposium and for your engagement with all of our guest speakers. Now, I have the privilege of introducing our next guest speaker, Mr. Ryan Semerad. Ryan grew up in upstate New York and attended Union College. He's graduated from the Ohio State University Moritz College of Law in 2016, and he's clerked for Judge Michael P. Gibbons of the Nevada Court of Appeals in Las Vegas, and after his clerkship, he practiced at Holland and Hart. Ryan moved to Wyoming in 2020 with his family and is now the current owner of Fuller & Semerad, a criminal defense-based firm with some civil work in Casper, Wyoming. In 2021, a colleague asked Ryan if he'd be able to help with a criminal trespass case involving corner hopping. Now, as a New Yorker recently relocated to Wyoming, Ryan agreed to help, assuming that corner hopping was some kind of low-level rural mischief like cow tipping. What Ryan could not have anticipated was that this case would evolve into a landmark case for Wyoming and potentially for the entire United States, widely recognized today as the Corner Crossings case. Ryan's involvement as a defense attorney for one of the hunters in the Corner Crossings case led him to writing his article for our issue, 3-Inch Teeth, the Flawed Criminalization of Corner Crossing in Wyoming. Ryan's article and presentation today focus on how corner crossing came to be considered a crime in Wyoming and why that interpretation is fundamentally flawed. Many view the Corner Crossings case as a straightforward instance of trespassing, but like Joe Pickett in 3-Inch Teeth, they fail to see that upon closer inspection, it's something far more complex. Ryan's hands-on experience with this case and his deep understanding of Wyoming law provide an interesting and insightful perspective on how land ownership, access rights, and public policy intersect in unexpected ways. As a reminder, there will be a Q&A portion at the end of this presentation as well, so please refrain from asking questions till the end, or use the QR code on the tables or in your brochures to ask them online. Now, everyone, please help me give a warm welcome to Mr. Ryan Semerad.
Thank you so much for that welcome. It's great to be here. I am very excited to present this issue with the framing of the C.J. Box novels. And on a particular day, the Supreme Court of the United States just met yesterday to confer about a cert petition on this issue. I don't know. So we'll find out on Monday. Stay tuned. So I'm Ryan Semerad. Thank you for the introduction, Kaylee. That's kind of got a little flavor of who I am. It's incredibly odd for me to be standing here for all the reasons Kaylee said. In law school, I was talking to Craig Silva in the breaks. In law school, my absolute least favorite subject was property. I am not a hunter, and I've never owned a gun. So it's perfect for me to be the corner crossing lawyer because I'm the right person for the job. Nevertheless, 3-Inch Teeth and corner crossing and my approach to this issue. So I am, by trade, a criminal defense attorney. Hearing a lot about those jurisdictional issues in the last presentation makes all sorts of wheels spin in my head. It actually got a Yellowstone Park case that's going to trial in December, so maybe we'll find some more oomph this time to see if there's something interesting that can be done at the 10th Circuit. But when I approach criminal law, I think about criminal law in a different way because I do this boots on the ground, hand in the dirt all the time. Criminal law is something different than the way we often react to it. We're very interested in criminal law as a society. Lots of fiction is predicated on crime and true crime and near true crime and based on true events, but not really, and that kind of stuff. And now that's not exactly 3-Inch Teeth. There's a corner crossing element to it, and I'll get into that in a second. But the purpose of this presentation, and I want to focus your attention on, is what criminal law, what crime really is the heavy artillery of government. That's crime. bad behavior, immorality, that's for philosophers and school teachers and parents to try to teach behaviors and etiquette and communal norms. But what the criminal law is what the government can do to you in a big bad way, and should they? And as the previous presenter said, the Constitution's purpose is to put limits on the government. And so this presentation is to try to walk through how we walked into this situation where everybody assumes corner crossing is even a thing. Check your statute books, not there. And why we assume it's controversial. Who thinks it's controversial, and why that matters. 3-inch teeth uses this thing called dramatic irony. I was an English major, so this is just all sorts of fun for me to do this. Dramatic irony, it's when in literature or in a TV show or movies, the audience knows something the characters don't. We're privy to stuff, the characters are navigating it, and we're like, ooh, 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 we know. And I think that framing device is so useful for understanding the corner crossing issue, because as my take on 3-inch teeth is, what appears to be a believable but unexpected deviation on natural forces is not natural at all. Instead, it's artificial and motivated by bad intent. There will be some spoilers, so I'm sorry if you haven't read the book. Sometimes there's no bear in the woods. It's just a man with his evil mind. And in 3-inch teeth, after our narrative hook, we get introduced in the opening of the book to this bear attack, or seeming bear attack. The narrative unfolds after that with Joe Pickett encountering some Pennsylvania hunters who happen to be corner crossing. And he says to them something to the effect of, now listen, it's no violation of the hunting and fishing regulations, because he read the 2004 Attorney General memo we'll return to in a moment. But the sheriff, he might arrest you. I can't stop him if he does. And the Pennsylvania hunters say, we'll take our chances. My favorite, we lost some, we're going to just roll without it, I guess. Oh, it's back. Okay. My favorite aspect of this, and I put this in my article at the very beginning, is Clay Hutmacher Sr. He is the manager of the Double Diamond Ranch. His son is missing. He calls Joe Pickett to tell him, my son is missing. Well, Joe thinks he's calling about the corner crossers. And so Joe's like, oh, I know, Clay Hutmacher is so mad about corner crossing, he forgets about his son for like 4 pages. He's just like, you've got to be kidding me. How dare they? I am up to here. His son is missing. But the big thing is the corner crossing. I think that this just goes to show that maybe this corner crossing thing is touching on something deeper than this footfoul that it tends to actually be. So for those who are uninitiated, corner crossing is when a person in a certain land pattern that looks like a checkerboard travels from the public land to the public land over a corner. Corner crossing. You could do it with a ladder. That's my friend Zach Smith up there. He's a client of mine. We'll talk about that some more in a bit. Before we get to this, I talk about corner crossing often. And I don't know what the end result is going to be. We haven't finished the fight. So far, it's gone well. We could lose, of course. And that's something that I recognize, because I'm not going to talk about the civil reality, whether it's legal, whether it's illegal from a civil perspective today. That's what the Supreme Court is going to tell us eventually, or not. What I'm here to talk about is the criminal aspect of things, but I think before we get there, it's really important to understand how we got to this even as an issue. Those who cannot remember the past are condemned to repeat it. So we should go through the past and go back to my horror stories from law school, which is the bundle of sticks we learned about in property law, the checkerboard, and then my friend Zach with his ladder. So property rights are often referred to as a bundle of sticks. I don't know why they decided to say it was a bundle of sticks, but that's what they all say. And the one bundle, or one stick in the bundle, is that you have the right to exclude people from the things that you own. And that is the most essential stick in the bundle. And then you have the Union Pacific Act of 1862, and you're going to say, Ryan, what and how? Well, what and how is property rights is what you have. The Union Pacific Act is why we ended up with this land pattern that looks like this. And we need to understand how we got there to understand what these property rights actually mean for people that own land within that checkerboard. So here's a fun fact. Between February 19th of 1846 and July 4th, 1848, we gained 1.2 million square miles of land. That is a lot of land. 2 years, 4 months, 15 days, that much land. Do you remember this when the Titan submersible imploded? That was about the same amount of time ago. Could you imagine if from that moment to today, we gained all of Mexico, Guatemala, Honduras, Nicaragua, Belize, El Salvador, Costa Rica, Panama, and half of Colombia? That would be the equivalent time frame and quantity of land. That's what happened between 1846 and 1848. It was not the Louisiana Purchase. It was everything else. This section here, these sections, that's what happened in 2 years, 4 months, 15 days. Our country erupted in growth. And with this big bad country, we now had to figure out, how do you get from here, the east, to there, the west? And why? Why was this so dang important to figure out how to do this? Well, there was this thing called Sutter's Mill, and there was a guy who was out in the river right by the mill, and he looked down and he said, there's something in here. It's kind of shiny. That might be gold. And then all of a sudden, everybody and their brother said, we absolutely need to get to the west. It's very important that we get to the west. There's a lot of interesting things, cultures, and peoples, and we need to get there. And before we had any direct routes, we didn't have airplanes, we didn't have the automobile, we didn't have roads. You had a few different choices for your sea map. The reason this map is so big and crazy is because one of the common routes was going around Cape Horn, which was a 6 to 8 month sea voyage from New York to end up in San Francisco. I can't imagine. This is 1851, 1852. You're going to take a boat all the way around. Or you can go through the Panama Canal, which was also not a safe journey either. Or then, of course, we have our Oregon Trail, and you could give that a go too. So Congress was very preoccupied in this moment. Antebellum, we're not quite at the Civil War yet. We just found gold. We just expanded. And they say, we need a train. We need a transcontinental railroad. But how? Today, we think of the hot constitutional debates in this country about abortion, executive power, tariffs, so on and so forth. Different debate in the 1830s, 40s, and 50s. It was about internal improvements and how to fund them. Internal improvements. Can Congress directly subsidize companies, whatever, to build things like a railroad? And everybody thought the answer was no, you can't just give them money. I know it seems weird today because we seem to give out money quite frequently now, but, different times. So what they thought of was this thing called checkerboarding. In the article, the only way I can ever conceptualize the economics behind checkerboarding, English major, not an economics major, is the concept of drafting. If you watch any racing sports, the idea being that if you can line up behind the person in front of you, you can take advantage of the reduction in the friction from the air, and you can basically be more efficient, and you can go faster for longer. So what checkerboarding was, is we knew when we surveyed the lands, we created these sections that look like this with all these crazy snaking numbers, 1 to 6, 7 to 12, and then back and forth. Each one of these numbers is a square mile section, and they're called townships. And we said, okay, what if every other section we give away for free, we retain the other sections to the railroad for every mile of track built, and as they build out their track, their lands will be developed, people will build up towns and stations, and they'll be inspired to do these things. We don't have to pay for any of it. And as it develops, our retained sections will double in value. Economic proposition. We don't pay anything, but we get something and they get something too. That was the idea behind checkerboarding. These private sections would basically be given to the railroad, the public sections would be retained by the government, and ultimately they could sell those lands later on once everything was developed and make money. That was the concept. And I'll skip over, these are just some language that basically says what I just said. It came from the other side's brief, so I don't mind skipping it. But in any event, they were very smart lawyers and they wrote a very good brief. But the problem is, as anyone who resides in Wyoming knows, is that there are parts of Wyoming that are quite arid and perhaps are not great places to develop into towns and metropolises, and they're not going to turn into much. So this idea that the land is going to develop and you can turn around and sell your land for a profit actually became impossible. So what happened when they discovered that you couldn't sell these lands is they tried to let people homestead them and effectively give them away that way. And then when that failed, they eventually switched policies all the way. We can get to 1976 and the Federal Land Management and Policy Act. They said, we're just going to keep these things. We're just going to keep them, and they're going to be public, and they're going to be used for public uses of various sorts. So we still have checkerboard in Wyoming. That's kind of how it still happens. Well, I bring up the Civil War and the attack on Fort Sumter simply because that is how, that's one of the motivations for putting the line where it was. There was obviously disagreement constitutionally about how to give away these lands, and when half the country just decided to leave the government, it became much more simple to just pick a path. So I'm also going to skip past that for the purpose of this presentation. So this is Promontory Point. This is when we finish the Transcontinental Railroad. So now we have the road, or the route completely built. The Golden Spike is laid. We have our railroad. And of course, the checkerboard section is retained because Congress couldn't give it away, and we've decided to keep it. At each of these corners, there are boundary markers called monuments. In the past, rocks, sticks, mounds, trees, tree carvings, and dinosaur bones were used. Today, we have standardized die-cast brass caps. These are just some pictures. This is a standard brass cap. This is, I think, a rock. And there's checkerboarding all over our country here. So that's why we have these checkerboard lands. And in Wyoming, right here, you can follow along our path, 20 miles north and south. That's where our checkerboard lands are, and obviously a big chunk of it is in Sweetwater County. But that gets us to kind of the rub of this issue. Corner crossing versus corner locking. If we still have checkerboarded lands, the question is, if I want to go from section 24 in the top left to section 14 or section 30 in the bottom right, can I step over that corner, or is it some kind of violation? Is this cool, or is this the rule? What is the answer? Seems super boring or super trivial or super why does anybody care, except for the fact that it impacts something like 8.3 million acres of public land. That's 3.5 Yellowstone parks for our last presentation. So now to the guts of this presentation. Is corner crossing a crime? Remember I said at the beginning, something I'm very preoccupied by is the power of the government, and can the government do what it wants to do? So if something is a crime, that means the government can take action. That's what makes it a crime. And in particular, the action they can take is they can punish you. Dramatic irony is that I'm standing here today probably because you know that they were found not guilty and then things have gone well thus far. And if it had gone the other way, maybe it would be a different presentation. I don't know. That's my dramatic irony. But I still think that this requires a serious treatment to understand each part of the question of whether corner crossing is a crime. And it begins with, of course, the essential question: what is a crime? Well, is it these bad guys in their black and white shirts? Walter White? Is it The Wire? We often feel crime, is how I think about it, as a society. We identify that this is a crime because it feels like a crime. And what all of these fictional shows do, and this is, of course, the greatest movie of all time, Christmas Story, Breaking Bad, The Wire, what these shows and movies play on is this tension between what, we humanize some of these characters. We start to discover that there's aspects of who they are that maybe justifies, motivates, or mitigates what they do. But that's a kind of emotivism, okay? That is boo hooray ethics. If it feels good, it's good. If it feels bad, it's bad. That is moralizing, and that's what we do when we do storytelling. That's the purpose of storytelling. Way back when we were all in tribes sitting around campfires, we would tell stories because they taught us lessons. That's how we conveyed the rules of the road. And in fact, before statutory codes and the model penal code, common law was judge-made law, which was really just storytelling of this is what the code is, this is what our moralities are. But that's not how it is today. When we do emotivism, we are not stating truth-evaluable propositions. We are vibing. We are just saying it feels good, feels bad. That's really all we're doing. Crime today is something different. Crime today is something that is a transgression of an established social or communal norm that is protected in a public law and that subjects the violator to punishment, including the loss of life, liberty, or property. And according to a criminal law professor from my alma mater, crime's distinguishing feature is the social condemnation and stigma that accompanies that criminal conviction. To indict, there's an expression, to indict is to destroy. If you walk away in handcuffs, nobody cares if you have a great attorney who proves it wasn't you. The headline is still going to be Ryan Semerad arrested on stage while giving presentation for something horrific, right? That's what it's going to be. Reputational harm matters, and people file lawsuits about wrongful arrest all the time. It happens. To indict is to destroy. For my purposes, I think what matters most is not the social condemnation and stigma. That's an important part of what makes something a crime. But what really makes it a crime is who does the destroying. Another feature, public attorneys representing the community as a whole. The government, as I put in my article, what makes something a criminal law is that the statute can transcend the text. It can take human form with a gun and a badge and handcuffs, and it can come and get you. There are very few laws that can do that, but the criminal law can. The government does this. Recall Reagan's famous 9 words. As you remember, I'm from the government and I'm here to help. That leads me to my favorite work of criminal law fiction, which is the Watchmen graphic novel, and the question of who watches the Watchmen. What are the limits on the ways the government, through prosecutions, can use the criminal law? There are a few, there's many more than this, but there's a few that I'm going to focus on for purposes of this analysis of whether corner crossing was properly criminalized. First, in Wyoming, the legislature must determine what conduct should be criminalized. It is to the legislature. We've abolished common law criminal lawmaking. It has to come from the legislature. Second, they have to pass a relevant law before the act occurs. We talked a little bit about ex post facto in the last presentation. If we want to boil that down to its simplest possible essence without getting too crazy, because there's some crazy wrinkles in the constitutional law, you got to pass it before it happens. The law must be sufficiently clear to give notice of what the conduct is that's criminalized. It can't be vague. It can't say, the crime is dressing poorly. Okay, well, what does that mean? It's not beauty in the eye of the beholder, all those kinds of things. And it must establish minimum guidelines for enforcement. We must have a way for law enforcement to be able to go out into the world and say, the legislature has said this conduct is a crime, and we know how to identify it, and we know how to uniformly treat it. This gets a little squishy when we talk about our speeding ticket friends. Sometimes you get pulled over going 5 over, and they're like, hey, don't do it again. Sometimes you get pulled over going 15, but you say, my wife's pregnant, I got to get her to the hospital. And they say, oh, okay, totally cool. And then other times you end up in handcuffs for the meth in your trunk, and then you call me. I promise I did my homework on this. There's law for all this, but we're going to skip past that too. Okay, so the gist is laws must define what the crime is. Okay, going back to who watches the Watchmen. And legislatures must pass those laws. And voters must pick the legislatures. So therefore, voters, we all control what is crime, whether you believe it or not, because that is how our system works. It is not just a story. It is not just a feel. There has to be a law, and lawmakers have to make it, and voters have to pick lawmakers. Okay, so back to the question, is corner crossing a crime? Okay. Or do people just hate corner crossing? They just feel bad about it. Is there a bear attacking people, the natural thing, the criminal law establishes it's a crime? Or is there a man attacking people, making it look like a bear is doing it, which is a man-made problem, right? The bear, the natural thing. Okay, has the Wyoming legislature enacted a criminal law that makes corner crossing a crime? You would think so. You would think so. Maybe. Okay, there are two possible choices. Criminal trespass, trespass to hunt. Those would be your two statutes that we would say make it a crime. And this is what the legislature is currently trying to think about right now. In fact, they're trying to amend this statute, and there's been some conversations about whether they ought to. Let's go to trespass to hunt, because this one is about as clean and clear as it can possibly get. Prior to 2023, this is what the statute said. I'm not going to read it to you because this is how they write statutes, and for law students out there, never read the statute this way. Diagram it. Go back to grammar school. You'll help yourself, or read the jury instructions, even better. Okay, so break it down into parts. See, no person shall, blah, 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 but I fixed it a little more, make it more simple. This is what it is. No person shall enter upon private property to do hunting stuff without the property owner's permission. That's effectively what trespass to hunt was. And the Attorney General wrote this memo in 2004 after somebody was acquitted at a bench trial of trespass to hunt for a corner crossing allegation. And they said, enter upon private property is not the same as momentarily traveling above private land. If the legislature wanted to criminalize momentarily traveling above private land, they'd have to change the statute. We're judges. We don't stretch statutes or expand statutes. So, well, they're not judges, but judges shouldn't do that. So therefore, trespass to hunt is not going to fit the bill. And then in 2023, the legislature actually did amend the statute, and they amended the statute to make it quite clear. Travel through or return across is what the criminal act is, and they defined travel through or return across to require physically touching or driving on the surface of private property. Okay, clear as a whistle. Corner crossing ain't trespass to hunt. Boom. Great. Not a crime. What about the man faking bear attacks? The unnatural thing. That would be airspace. You may say to yourself, Ryan, why are you talking about airspace? Where are we going with this? Well, you see, my friends on the other side of this issue seem to be very, very concerned about people displacing their airspace. The thing I don't understand is how you live in Wyoming and are worried about air moving, considering what a windy place this is. Nevertheless, that seems to be their bugaboo, so let's talk about it. So they go to criminal trespass, and you may say, okay, airspace, criminal trespass. Ryan, how are we getting there? Well, we're getting there, and I'm going to move past all this for a second too, because the same Attorney General memo that said that trespass to hunt is so quite clearly not criminalizing corner crossing says there is this question. There is this question. Does a landowner own the space above the land? And if so, does someone who merely passes through it violate the criminal trespass statute? And you might say to yourself, why are they asking this question? This seems like a non sequitur. One would think that. Let's go back to the statute. Okay, this is the full statute. I'm not going to dwell on it long because I'm going to break it down. It was proposed in 1982, 1983. There's been no amendment since, and it was derived from the common law, which, as I mentioned, the Wyoming legislature has abolished for purposes of the criminal law a long time ago. The statute reads like this. It's a trespass if you enter or remain on or in the land or premises of another, knowing you're not authorized to do so or after being notified to depart. Does anyone in there see the word airspace? Yeah, I didn't either. So, okay, break it down some more. Entering on, remaining in someone else's land or airspace, and then you have to pick another one, knowing you're not authorized or after you've been notified. So where are we getting airspace or ownership of airspace into this statute? Well, they're not really saying it in this phraseology of entering on or remaining in. Where they're getting it from is that in the common law, there's this thing called super-adjacent airspace. And back when they passed the Union Pacific Railroad Act and checkerboarded the lands, we didn't have airplanes, and we didn't have vehicles, there weren't really this focus on airspace rights, and we didn't have Chicago, and Cher didn't sing a song about who owns the rights to airspace and all that good stuff. But there was a common law understanding that if you owned land, you owned from heaven to hell, and that must include the airspace. So that's what they're kind of lumping in, is that it's part of that bundle of sticks I mentioned at the beginning, is when you own land, you own air. But it certainly doesn't say that in the statute anywhere, and if the Attorney General had an issue with entering on in the trespass to hunt statute, I don't really understand how it's any different in this statute, but let's dig into it. So what they really do, and I'm going to skip through this for a second, they add in airspace to the definition of land because of this other statute in Title 10. And this other statute in Title 10 says, ownership of the space above the lands and waters of the state is declared to be vested in the several owners of the surface beneath, subject to the right of flight. And again, I don't see any of that in the trespass statute. I don't see a reference to it in the trespass statute, but that's kind of their thing. So it seems to me that they're adding some stuff into that definition of land, and then they go to this random dictionary from 1995. It reminds you that the statute was passed in 1982 or 1983, but they picked Webster's of 95. They wrote this memo in 2004. I don't know. Now it's just potpourri. They're just doing what they want. And they say that you can add in a bunch of different terms that basically say, maybe. It may be criminal trespass. Maybe. It's hard for me to really take this stuff seriously, obviously, as you can tell from my tone. And the main reason I can't take it seriously is it's just so dang fudgy. I mean, you're picking up a statute that's not referred to in another statute. You're calling land air. You're picking up this dictionary. I don't know why this one. And you're saying that even after all of that, the best you could say is maybe a crime. Okay? Sounds like minimum standards for enforceability to me. So I just have some bones to pick, as you can tell. They're saying because we know you own land that gives you ownership of the airspace, that's how we kind of fit this all in. But there's a few other problems. So the legislature also said that the sovereignty in the space above the lands and waters of the state rests in the state, except where assumed by the United States law. So there's that problem. And then there's the Supreme Court's statement that the mere fact of overflight without evidence of impact of the surface does not amount to a taking of the landowner's property. But they still say that this is entering or remaining on the premises of someone else. And then you have the 10th Circuit that says traversing the airspace above a plaintiff's land is not of itself a trespass, and traveling through airspace is lawful unless done under circumstances which cause injury. Oh, and then you have the Supreme Court that says because there has been no actual effect on the property itself, there is no trespass. So I am all the more confused about how we get from this to the AG's memo that says it is a trespass. But that is their theory. Oh, but then the AG says this fun thing. Clearly, the defendant's reason or purpose for trespassing, to hunt or fish or trap, is the only difference between trespass to hunt and criminal trespass. Okay, so if corner crossing is not trespass to hunt, and most corner crossers do so to hunt public land, and that's the only difference is the rationale, I don't understand how we avoid your conclusion that we can't enlarge, stretch, expand, or extend a statute to matters that do not fall within its express provisions. Such a construction is not permissible. I'm at a loss. And then what about these other elements? Knowing you're not authorized to do so after being notified to depart or trespass. Knowing, okay, not authorized by who? How would we know you're not authorized to corner cross? And the reason I flag this particular element, save for the fact that it's required for it to be a crime, is that we have some pretty strong Supreme Court case law that says these things. The nation's public lands are held in trust for all the people. We are of the opinion that there is an implied license growing out of the custom of nearly 100 years that the public lands of the United States shall be free to the people who seek to use them where they are left open and unenclosed, and no act of government forbids this use. There are federal statutes that say it is free passage or transit that is to be unobstructed. Passage or transit is free in the sense intended when it is open to all, and when some withhold it from others, whether permanently or temporarily, it is not free. How do we take these statements to make it understood to a regular person that if you are going from public land to another section of public land, that you are not authorized to do that? It seems pretty clear to me that our Supreme Court quite clearly thinks that it's for you to use. Back to our criminal trespass statute. And then there's this notification issue, and it says after you've been notified to depart or to not trespass. I always love when a statute says it is illegal to violate this statute. Thank you. That's very helpful. So let's at least look at depart. What does it mean to be notified to depart? Depart means to go away from. So to go away from means to go away from the air? And how would one be notified to go away from the air exactly, I wonder? Maybe this isn't about airspace at all. This is some stuff from our pleadings. There are millions, as I mentioned, 8.3 million acres of public land that are affected if corner crossing is illegal. If it's obstructed, you can't do it. 8.3 million acres of public land become totally inaccessible to the public and under the de facto control of the adjacent landowners, whoever they may be. If true, those lands are just totally inaccessible. Perhaps there are people who benefit from corner crossing not being lawful access. Perhaps. Perhaps there's a man faking bear attacks out there. Don't know. This is Elk Mountain. This is where the rubber meets the road in my case, and I'm going to skim through this because I want to make sure we have some time for Q&A. This is what the land looks like in the relevant area where this case all came from. That's the very first corner. This is what's at the very first corner. See how it clearly says depart the airspace? Do you see how it clearly says that the airspace above this land is vested in us and you should never step over this? Would it surprise you to know that directly between those two signs, on the other side of those signs, ain't private land? It's public. Because it is. The person that took this picture is standing on public land, and directly beyond those signs is public land. It's those two yellow corners right up there in the top left. But those signs seem to make it sound like you shouldn't go there. These are four guys. They're from Missouri. They decided they were going to go there. In 2020, 3 of them went for a hunt. They encountered those signs and they swung around them. They ran into a ranch manager who called the sheriff. The sheriff came out, talked to them, and they told them exactly what they did. And the sheriff didn't cite them. Said, okay, well, be safe out there. Go on your way. So did they get much notice they weren't supposed to do it? No. The big complaint was that they touched the signs. So in the next year, they brought a ladder. And now they're not going to touch the signs. And that didn't go so hot. People got mad. So the ranch manager stalked them out, scared off game. He called the game warden and the sheriff. I've got recordings. They're really interesting. Calls and calls and calls. The game warden meets with the hunters and says there's nothing to do. It's all good to go. County attorney thinks otherwise and instructs the sheriff, not the game warden, to cite them for trespass. And they got cited, and then they decided they're going to go to trial. We filed some pretrial motions. We really tried to explain this is not a good case, and it didn't work. So we had to go to trial, which was very interesting. This trial took place in Rawlins in the spring of 2022, and anyone who did any trial work at that time knows that their courts were under construction. So we had to do jury selection in a community center, which was cool. And then we had to do trial in this little makeshift room where we stacked up desks on top of each other. And this was all of us trying to listen to the judge. And this is what the room looked like with that nice pole right in the way of the prosecutor's table. Just this really duct taped together situation. And the prosecutor made this argument in closing. Landowners don't just own the land, you also own the airspace. Huh, where did I hear that before? Wonder why that's what the argument was going to be. And I had a different argument. I said, first, well, let's see, legislature must determine that conduct should be criminalized, they must pass laws, they must do all these things. Let's see. The legislature must determine, they must pass the laws, and it must be sufficiently clear. The state told you the law was clear on this. It's clear as mud, is what I said. What a great phrase, because what does that say? It says that it's not criminalized. And then also you heard that a deputy from the Game and Fish, well, I should have said warden. Maybe this article wrote it wrong, but the game warden wouldn't cite them for corner crossing, and the sheriff's deputy from 2020 wouldn't cite them for corner crossing either. So minimum guidelines for enforcement, that seems like a problem too. 3-inch teeth, Joe Pickett. He could do nothing to prevent their arrest by the county sheriff if that office decided to pursue it. Such a strange feature of corner crossing prosecutions. You know, it's rare. I get the 5-mile-an-hour speeding ticket. But what about the assault? What about the murder? You know, we're not talking about a jurisdictional issue. If somebody admits straight up, I did this thing, how could it ever possibly be the case that sometimes it's a crime and sometimes it's not? That doesn't seem like there's any guidelines for enforcement. It seems totally ad hoc. That seems like a problem. And then recall that crime is a transgression of a social norm, that it's about stigma, that it violates some communal understanding of what's right and what's wrong. Well, again, the nation's lands are held in trust for everybody. These are free to all people who seek to use them. When some people withhold it from others, it's not free. They're doing something wrong. So who is violating the communal norms when they stop someone from accessing the public land? Then I said something about kings. And I said that it seems to me that the landowner in this case believes that he has some kind of superior right, some kingdom over these public lands, and that that's the problem. And that's not how the criminal law ought to work. Ultimately, the jury found us not guilty, and they, of course, don't tell us why, but they didn't buy what the state was selling. Now, of course, we're waiting on the Supreme Court. We'll find out, honestly, on Monday, 7:30 in the morning, our time, 9:30 Eastern time. They should be issuing an order list that will say, I mean, they could just relist it and it'll be kind of a nothing burger, but they could grant cert, and then we'll really get an answer on whether this is right or wrong, or they could deny cert. The 10th Circuit certainly invited them to do some things, so we'll see if they take up either of these requests from the 10th Circuit. And it only takes 4 votes, so for those interested, we just need 4 of these people to say they want to take this case, and we'll be there. But my point for this presentation is this. Criminal law is the government's heavy artillery. They can come into your house with a warrant, they can stop your vehicle on the side of the road, they can slap very fancy bracelets on your wrists, and they can put you in a box. It's incredible power. And all of us as voters, through our legislators, we make decisions all the time about what we want to be criminalized. And if we don't criminalize something, if our legislature hasn't gone that far, it should not be a crime. It's that simple, especially with all the other issues that exist with the statute and my analysis of this case. So going to 3-inch teeth and going to this question of this notion, this horrible act of corner crossing, whether it ought to be criminalized, whether there is a real bear out there or whether there's bad motivations. I think there's lots of bad motivations. I don't think there's a bear out there, and I don't think it should be criminalized at all. And I'll leave you with this. I always end this presentation with this notion of why these lands are so important. We need access to these wild places. We need the ability even to just be exposed to them, to see them. It matters so much because we are not just our jobs. We are not just these, we don't just live within civilization and the societies that exist around us. We need exposure to remind ourselves to what the world really is and how unique and special this place is. And that's really all we're asking for by telling the the government, please, respectfully, if you're going to make it a crime, but if you're not, leave us alone. And I'll leave it with that, and thank you for your attention.
All right, I think we'll switch over to some Q&A. So we'll do live in-person questions first.
So a thought and then a question. So I'm from Alabama, and in Alabama, the state owns the bedlands of rivers only to the low water mark. And so when rivers are flowing up to the high water mark, private landowners cannot protest the user of the surface of the water for floating over their private land, right, as long as they don't touch the bank. And so it seems like a similar theory, right? Like, so I'm just wondering if there's an analogy between, I guess this is a question, an analogy between the way Wyoming treats use of surface waters and the corner crossing issue. And I'll just throw out my other question, which is, you know, we do accept that law enforcement officers exercise discretion, right? Like Joe Pickett exercises discretion not to ticket people when he believes that they're fundamentally good-hearted, right? So like not Ike, who's a man who suffered a brain injury, doesn't have his fishing license, and Joe doesn't ticket him and even offers to buy him his license, you know? So I don't think it's discretion per se that's the problem. It's that it seems like you believe the discretion is being exercised on behalf of the wrong kind of interests. And I guess maybe that's a thought too.
Sure. Yeah, in the water question, the Wyoming Supreme Court does have a very similar decision about surface water. What I have discovered is a lot of our airspace case law, though, is all flight related, of course. That's when we really started to treat it seriously. And then, of course, power lines, and that was actually the Edgecombe case I referred to as a power line case, and what that means for trespass law. I think there's an analogy there for sure. I think that the posture of the criminal case was challenging to raise a lot of these issues because a criminal case is a poor vehicle to litigate property rights. Maybe that's why it shouldn't have been prosecuted. That's another reason. But going to this law enforcement discretion, you'll find no greater champion of good law enforcement than me, I promise you. And the thing is I know this from talking to law enforcement in my job. They don't want to prosecute this, charge it, or investigate it. They've got better things to do. But the reality is, you know, they've got their hierarchies and power structures, and they've got to respond to that too. But I do think that largely the discretion has been exercised to say we're not charging for this. We've got other things to do. It's happened 3 times, 4 times in this very case until a decision was made by somebody else. But yeah, I mean, I think law enforcement knows they've got other stuff to do too. Yeah.
Presuming that the Supreme Court votes in favor of the hunters and corner crossing is allowed and legal, should landowners who bought expensive ranches under the presumption that all of their land, checkerboarded or not, was theirs, be compensated for their loss?
Yeah.
Wouldn't that be a taking?
This is the question, and my answer to this is no. And that's because they didn't buy that. They thought they bought that, but they didn't. And so if you have this expectation, I bought 6 pieces, but I thought my purchase of those 6 pieces gave me control of 12 more pieces, but it didn't. Your mistake may be well-intentioned, maybe not, but it was a mistake. And you don't get compensation for something that you never had. You never owned it. It was never yours. It may be a thought you had. It may have been the primary motivation for why you purchased those 6 sections. But your strategy or your strategic thinking was wrong, and that because that premise is false, you actually never lost anything. You just lost the idea of the thing. So no, would be my answer. Yes, ma'am. For the property owner to just buy the public sections? Theoretically, yes. I mean, they'd have to negotiate with the relevant agency, the Department of Interior, BLM, typically you'd have to have some kind of process that would follow FLTMA's regulations for selling land, which are relatively restrictive. The idea is to retain the land. That's the primary thrust of the legislation, and Congress is, at least up until Mike Lee got involved in the spring, was to keep the land. So you could, it may cost you a pretty penny, and it may take a lot of time and effort and energy, but theoretically you could, yeah. Yes, ma'am. Yeah. There have been a lot of the phrase often used as land swaps is we'll swap and we'll just, you imagine if you just swapped all the sections, then it becomes two bands instead of checkerboarded. It's just a white band and a black band, or a red band and a black band, whatever you want to imagine your checkerboard as. The land swaps have never really, obviously, have not fully matured in this way. And I think that's because often some sections have more value than others. Some sections have extra features that others don't, and it's not going to wash out in a clean and easy way. And then, of course, you have topography like Elk Mountain and its summit. Who gets the summit, and who's going to, who's going to be king of the mountain, right? And there's going to be some negotiations that are just, I don't think we'll ever get past it. So at least so far, it hasn't happened. It could, it just hasn't. Yes, ma'am. Yeah, they could. That would be a taking. I will spot you that if there was some actual condemnation of private property, the estate, subsurface, surface, super adjacent airspace condemnation process, that would be a taking. And they'd have. Well, if you hire the right real estate appraiser, I can tell you it's $9 million. But if you hire a reasonable real estate appraiser, perhaps it's a lower price. And this would turn into the litigation question is what is the just compensation for that? But they could, yeah, that's another thing they could do. Yes, ma'am. Yeah, I mean, anything like that, any kind of, restriction, whether we want to call it an easement, a servitude, whatever it's going to be, you could do it, but your answer you're going to get from the checkerboarded private landowners is, okay, now pay up because you took something from me. And then it's going to be the same question of what is the just compensation for that? How much? Is it every single section corner? And then you'll get questions from the other side, which are also fair, which is what do you do about state-to-state lands? What do you do about, isolated parcels that are totally encircled by private land? How do we get to those? So you could, it just would, step by step, we'd have to find the answer. Yes, sir. Well, I would love for them to do it because there is a statute I glossed over called the Unlawful Enclosures Act, which makes it illegal. It would be a crime or a civil sanction, and I guess the federal government would have to prosecute it, though I think they would do it through gritted teeth at this stage. That would tell you to remove that. So the big case, there was a flag there about the 10th Circuit said to the Supreme Court, maybe you want to revisit our decision in this case called Bergen. In Bergen, it was an antelope-proof fence that crossed the corner. It was totally on private land, except where it touched the corner. And the 10th Circuit said, you got to rip that fence out because it violates this federal statute that says you cannot enclose or obstruct passage to the public lands. Yeah, but I would like for someone to do it. I'm not sure if there's any other questions. I don't know if there's online questions or where we're at with time, but I'm happy to answer anything.
We have just 2 online questions.
Sure.
The first is, I'm not sure if you're aware, but the university does have an observatory that's based in Elk Mountain. So this question is kind of based off of that. It asks, is there legal protection for UW's Elk Mountain Observatory to continue corner crossing for federally funded scientific work under public interest?
So that how they get there is corner crossing?
Yeah.
Forever?
I think so.
Wow. Awesome. They should keep doing it. And they should call me next time. I'd like to go. I know that in discovery, we discovered that there are some agreements and payment plans that go on to allow people to get to Summit Elk Mountain for specific reasons. Utilities have that. And there's a telecommunications company that also has some kind of an arrangement. I don't know if it's a similar arrangement like that or if there's some kind of road they're using or something else. But at least for now, I mean, so the current status quo after Judge Skavdal's ruling in 2023 and the 10th Circuit's ruling in 2025, and despite this, even if the Supreme Court grants cert on Monday, that of course doesn't vacate or pause or do anything to the current ruling. They're good to go, so they can still keep doing what they're doing. That's cool though. I didn't know that.
Okay. And then the other question that we had is, how do law officials handle corner crossing when it's for environmental research?
So there is actually a separate trespass statute called trespass for data resource collection. So technically it could still be a trespass, although there was a First Amendment challenge to that statute, and I think it's basically been obliterated by that litigation. So prior to Judge Skavdal's decision, you could theoretically be exposed to, doesn't matter your purpose that you see in the statute, although the Attorney General says the purpose is the distinction between trespass to hunt and criminal trespass. The criminal trespass statute says nothing about your purpose. So I would think they would still be exposed, but now that there are these court decisions, the 2023 decision and the 2025 decision, they would again still be good to go. Yeah.
Perfect. Is there any other questions?
Well,
Okay.
Thank you so much for having me.